Hi everyone, my name is Jennifer Kupiszewski and I am with the Kyle and Kupiszewski Law Firm. And today we're going to talk about conservatorships. We do lots and lots of these. They're needed when someone doesn't have certain documents and they need someone to manage their financial affairs. And I've had some personal experience. My kids were in a car accident with me many years ago, and I was their conservator when they were minors. And I also helped take care of my mom. So I have a sense of what you're getting into and what it's going to mean. For today, what I'd like to do is most of the time when someone is filing for conservatorship, they have an attorney, but because it's financial, it's uncomfortable. But I want to pretend like you don't and really show you how it works. That way, whether you have an attorney or whether you don't have an attorney, you'll understand how the process works and sort of behind the scenes what is happening with your attorney when they are setting this up. So let's start with what the options are. The least restrictive option, the most beneficial thing you could do in terms of planning would be to have a durable financial power of attorney in place. If the person had that, then you wouldn't need a conservatorship unless an institution or someone is not willing to honor the power of attorney, or maybe you don't have the authority to do what you need to do within the power of attorney. That happens sometimes too. But if someone has this, they probably don't need a conservator. So what is a conservatorship? I want to clarify in Arizona that guardian is over the person and conservator is over the money. So if you're looking around online, you'll see a lot of states have them mixed in terms of guardian and conservatee. So sometimes they're the conservatee over the estate and the person, or guardian over the person and the person's estate. In Arizona, they're technically two separate actions. You can have just a conservatorship, which is what we're going to talk about today. So we're not talking about that guardianship piece. But a conservatorship, here you go, is to conserve someone's money. And so who needs one? Well, as I already said, it's somebody who didn't have a financial power of attorney. And it is also someone who, by virtue of some physical or mental impairment, they're not able to manage their own funds. And so their property is going to be wasted or dissipated. So a few examples of that, it might be that someone has forgotten where their assets are, and so maybe those accounts aren't being attended to. Maybe they're not paying their bills, and family can see that unpaid bills are coming in, the water's going to be shut off, and the person's just not able to keep up with their finances. Quite often conservatorships are related to needing to protect someone from exploitation. They've been scammed a bunch of times. They're vulnerable. Maybe they're being scammed or having money taken from them, even by a loved one. And so we need to become the conservator to stop that kind of behavior. A financial power of attorney can be difficult if you need to take really aggressive action against a third party, like an exploiter. A lot of times the financial advisor will come to the family and say, mom or dad is just not able to manage their affairs in the way that they were before. And so you're going to need to, if they don't have a power of attorney in place, you're going to need to be their appointed person. So I want to talk about what these court papers look like. You can look at any of these online. I'm pretty sure all of the counties or most of the counties have the court forms online, so you can go and look at what it is that needs to be filled out, what needs to be alleged. It's a stack like about that thick once you fill it all out. So I'm going to talk about the court forms, and I kind of followed their processes and their steps through them. They all have instructions really clear on all these different steps if you are attempting to do this yourself, or if you just want to know what it is that your attorney is doing. Okay, so step one is that you have to complete all of the paperwork. So there's the probate information sheet. This sheet, it's not a public document. It's got a lot of very personal information, height, weight, of, eye color of both the protected person, that's the ward, that's the person who needs a conservator, and the person who's petitioning or nominating themselves to be the conservator. A lot of very personal information. The court needs that so that they can identify who everybody is. It's going to ask for social security numbers because we're going to be dealing with assets, and also they need to be able to know who everyone is. That document is not anywhere that anybody else could get it. It's strictly within the court system. So that should give you a little bit of peace of mind because of the kind of information you're putting down on it. The next is a petition. So this is how we tell the court that someone is in need of a conservator. That's the petition. This is the shout out, the, hey judge, here's what I need and why. So it's gonna have all the information about the person who's petitioning and the circumstances, and then what assets need to be protected. The affidavit is what the person who's nominating themselves to be the conservator, that's what they fill out to say, hey, I'm a fit and proper person. I don't have any felonies. I'm stolen from people. I'm not on the elder abuse registry. So I'm a good person. You can trust me to be appointed. The petitioner's information sheet for the court investigator is literally that. It is very similar to the probate cover sheet, has some different information, but essentially this goes to the court investigator's office so that they can hand that off to someone to conduct their investigation, and they'll have everything that they need. And then finally, the notice of hearing, and that is what's going to tell people when the hearing is going to happen on this matter, and there will be a hearing. This is not something that can be done just administratively at the clerk's counter. So does it cost money to file? And the answer is yes. The court clerk is not free. There are filing fees for most things. There's definitely a filing fee to become the conservator. There's also the court investigator's fee that has to be paid, and ultimately the cost of a bond will need to be paid. If at the time of filing you don't have the funds, there is a packet, and so you could file for a deferral option offering to pay it later when funds have been secured. These costs get borne by the person's estate who's in need of protection. They're not borne by the petitioner. So let's say, for example, mom or dad need a conservator. They didn't have financial powers of attorney. They're not paying their bills. They're not sure where their funds are anymore, so they're just not managing their money. And one of the kids files to be their court-appointed conservator. So when the kids file, it's not ultimately going to be, the cost won't be borne by them unless they don't get appointed, unless they brought it maybe not in good faith. Other than that, it will be covered by their parents' assets. And so if at the time of filing, the kids didn't have the funds for it, they could seek to defer the filing fee until they were able to secure funds to pay the court fees. So the next thing is we need to obtain a hearing date. That varies, that process varies according to whatever courthouse it is filed in. So when you go up to the filing counter, of course, when I file, I know where I'm filing and I know what the process is. I know if there's someone there from the probate registrar who's going to be able to give me a hearing date, or how I would go about getting that. That is not obvious in the court forms, and they tell you that it varies from courthouse to courthouse. So when you go in and you go up to the filing counter, that would be something to ask the court clerk. At this courthouse, what is the procedure for obtaining a hearing date on my petition that I just filed? Excuse me. So you will have to provide notice of the action. And I'm gonna stop here for a little bit and spend some time here, because this is really important. This is a lawsuit like any other lawsuit, in the sense that you're going to court, you're asking for relief, and you are impacting somebody else's rights. That means you have to tell them about it. It would be fundamentally unfair if you filed a lawsuit and said, that person's dog bit my son, and then you never told them and you got them a judgment. right? That wouldn't be due process. This isn't any different. This, like any other lawsuit, the person has to be provided with notice. So what is that? Notice technically consists of the notice of hearing and the petition that was filed. In other words, whoever's going to be impacted by this, those are the two documents they need to get in order for you to have effective notice. The next question is then, who gets it and how? And at a minimum, it is the proposed protected person, because it's their rights, their finances that you're trying to take over, their rights that you're infringing upon. But then there are also other people in statute who are entitled to notice. Typically, just quick list, parents, adult children, spouse. They may all be impacted, particularly a spouse if the person who's going to be under conservatorship is married. How they're entitled to notice will vary. In those instruction packets, it says, so often the protected person needs to be personally served, the spouse, but other people you may be able just to mail them notice of the action. There are also other people who may be entitled to notice, and there's an analysis that needs to go through based upon the person's relationships, whether or not they have powers of attorney or revoking, and various things as to whether who else needs to be noticed. So the deadline for providing notice, you have to have notice done in enough time before the hearing for people who are impacted to take some action, such as hiring a lawyer or filing an objection. So the deadline in probate is in statute, and it is set. It's 14 days before the hearing. You have to have the notice of hearing and the petition out to all those people who are entitled to notice 14 days prior. So it's not magic. How's the court going to know you did all the things you were supposed to do in between? Well, we file what we call proof of notice, and that's simply a document that says, Judge, and to the other parties to the action, these are the people I sent it to, and here's how I sent it to them. You're also going to need to obtain counsel for the proposed protected person. And we call it court-appointed counsel because they are court-appointed. In Maricopa County, there's a list maintained by Maricopa County, the Office of Public Defense Services, of qualified probate practitioners who are on the list who can be randomly appointed to represent the person. The idea is that the person whose rights are being impacted is entitled to their own independent, objective counsel. There's a rule that requires that we get independent counsel. The concern is that a conservatorship can be used to take advantage of someone and to secure access to their funds. And we don't want there to be attorney shopping by the person who is the petitioner. So the court tries to protect people from exploitation. Part of that is making sure they have objective counsel who's just looking out for their interest, and not counsel who may also be working with the petitioner or proposed conservator and have a conflict. So in Maricopa County, a list is maintained. In other counties, there are referrals to qualified probate practitioners, and the process looks different. If you're outside of Maricopa County, that process will either be explained in their court forms as to how court-appointed counsel is found in their county, or you can ask the clerk's office when you go and you file how you would obtain and call and get that person. There is an option if the person has a long-standing relationship with an attorney that was secured prior to this action, that potentially that lawyer could continue to represent them and be their attorney in the conservatorship. That is a more complicated question that we'll have to look at during a different video as to what might be the circumstances in which that would be okay. Most of the time, you're going to need to obtain court-appointed counsel through one of these lists. In Maricopa County, the phone number is in the instruction sheets, and you just call, and then they call around, find out who's available, and they call you back and give you the name. I should say also that once you get that name, you have to give them all the same things that you had to notice for other people. In fact, you're going to give court-appointed counsel all of the documents that you have filed and other information that you have, because you have a duty of disclosure to them because they have been appointed to represent the protected person. Okay, what is a court investigator? So the court investigator, it serves solely at the pleasure of the court. They are court employees. They have been hired by the court. When I file conservatorships, I don't have any say over who's going to get appointed. I don't know who it's going to be. They don't tell me ahead of time. This is a completely independent process by which this individual is trained, it goes out and meets with people. Now I say that there is a global pandemic, and so they've had to adjust. A lot of these meetings are in person. Sometimes they're outside. Sometimes they're via FaceTime, but they're making those adjustments. Regardless, the court investigator is going to do their very best to speak with the proposed protected person and try to explain to them what the conservatorship is, what's going to happen, do they understand, how are they doing, and try to get a sense of what they understand and try to explain it to them. The court investigator is also going to talk to the petitioner and the nominated conservator. Most of the time those are the same person, but a petitioner can nominate someone else if they have a priority to be the conservator, and maybe it's not the petitioner. The court investigator is going to want to talk to the person who is going to be appointed to make sure that they understand their duties and responsibilities to this person if they're the conservator, and to understand why they have sought to be a conservator, and is it for a good purpose and not a bad purpose. So they're feeling all of that out. They write a report to the court. You will get a copy of that as a party to the case. That is a confidential document, not readily available to anyone else, but as the petitioner or someone else who's a party to the case, for example, court-appointed counsel, everyone's going to get a copy of that report to see if the court investigator recommends a guardianship, or sorry, a conservatorship, or recommends the person who's nominated to be the conservator. So this step is optional. As we said way back in the beginning, there does need to be some impairment. And so there's going to need to be some evidence of impairment that is causing this person to be unable to manage their financial affairs and to need someone to step in because their assets are at risk of waste and dissipation. So in the guardianship, there is a physician report. It's a court form. Everybody recognizes it. Doctors often recognize, oh, here's what it is. It's easy to fill out because it has check boxes for ADLs. It has places to write in the diagnosis. It directs the person, the physician or psychologist, exactly to what they need to be putting forth for the court. So I often use this form, even though it's not required in the conservatorship. It's just handy because everybody recognizes it and it's pretty easy to fill out. So I will frequently say to my client, here, take this, see if we can get the doctor to fill it out, and just specifically say to the client, make sure they're looking at it just for conservatorship and with an eye toward what is the impairment and how is it impacting their ability to manage their finances. The report is much more global than that because it has to do with guardianship and that finding that the person can't make reasonable decisions for their person, themselves, for medical or where they're going to live. So it's broader, but still an easy form. Alternatives could be a letter from the physician, or maybe there was an evaluation done that shows they're unable to really understand money. So there are other options that may be that evidence. Now, if the person contests, that means they object to the conservatorship and they tell their lawyer, I want to fight this and exercise my right to a trial. That medical provider, whatever that is that you obtain, will need to testify at that trial. If it is not contested, in other words, and I've done several of these recently where just the circumstances of the parents changed and they wanted help. And so we did the conservatorship, and they were in agreement. They said, yeah, I need the help. And so in that case, you need the original. That's what will get submitted to the court as a confidential document. It goes into an envelope, so not just anybody can read that protected health information. And then that original just gets admitted because no one is objecting to its admission. So step 6, you have to complete the court trainings. These are online. They are PowerPoints. They take about 20 minutes each. You definitely have to have the fiduciary overview and the conservatorship one before you can get appointed, because they walk through exactly what your duties and responsibilities are going to be to the person, best practices on how to be the conservator, such as you don't have a debit card, don't use cash. It's hard to account for cash. Keep your receipts. Really, really good practical information on being the conservator. Also, what those court obligations are, such as maintaining your address with the court. The third one on the court accounting forms, you don't have to do before the letters are issued. And oftentimes people use an accountant to do the accountings, and so they're less concerned about that. I would watch it just because the court accounting is cumbersome, and this is really, really helpful to help you understand, as you're the conservator that whole first year, what it is that you're coming up to, that all these actions that you're taking, how are you going to have to put that before the court for the annual accounting. So step 7, just a few more things, just a few little checkbox documents. I mentioned that the packet's about this thick. So these are all of the forms that are in the packet that will need to be filled out. This is what we do when we talk about, you'll hear sometimes our team talk about ancillary documents. This is what we're talking about. It's there's the petition and all the things that go with it to make the mechanics happen for that appointment. So order appointing court-appointed counsel. So once you get court-appointed counsel and you get that information to the court investigator, and if you decide to do the physician's report, then you got to get an order to the court actually formally appointing all of those people in those roles, so that they're on the hook with the court. Otherwise, you're not quite there yet. Just getting them, they need to be appointed. So the order to conservator, that is a lot like the trainings that you'll do. It is a very long document. It is a court form. Court spent a lot of time thinking about what do they want people to know when they're getting into being the conservator. So this outlines everything the court wants you to know. They want you to read it, sign it at the bottom, submit it to them saying, I read it, I know what I'm supposed to be doing, and yes, I'm gonna do it right for this vulnerable person who needs protection. So the order appointing conservator is actually, once you get all the way through, you have to submit it ahead of time. It needs to be submitted 7 days ahead of time, because the court needs a chance to look at your order, see if they have any issues in it, because they prepare ahead of time, right? The court doesn't, the judges, I mean, they're very dedicated, and so they do prepare ahead of time, and they're going to read through all this and make sure everything is in order, because they want their calendar to move forward, and they want to be successful in executing all these hearings. So they're going to be looking ahead of time. All this stuff needs to be to the court 7 days in advance. The order appointing the conservator is your order that you'll get at the end of the hearing saying, yeah, I approve what you've asked me to allow you to have the authority to do. And so that is the order that you'll get. It does not mean you're actually appointed. We're going to talk about at the end that next step. That's not the end of the yellow brick road. It's just another step on it. You'll also need your original signed training certificates. These are you filing with the court saying, yes, I've signed off, I completed the court required trainings. They won't issue your letters until you have done that, because they have to know, the court has to know, court appointed counsel has to know that you know what you're supposed to be doing on behalf of the protected person. Prior to the hearing, you're also going to want to obtain a bond. We're going to talk more about bond here next. but you're going to want to obtain your bond ahead of time, that original, to file with your orders and letters. Otherwise, you can't get appointed until your bond gets issued. So there's no reason why you would get your order and then not have your bond ready to get your letters issued. So have your letters and acceptance of appointment ready, because once we get all the way through all this at the hearing, these things are going to come together and they're going to work together to effectuate your appointment. So let's talk about bond for a little bit. This is something that I get asked about a lot. Why do I need a bond? I'm not going to steal. I didn't come to the court to be the conservator and do all this for the person I love because I'm going to take their money. Or, you know, I'm not going to mismanagement. Like I've experienced as a bookkeeper. I know what I'm doing. This is the kinds of things that people tell me, and I know they're right, and I absolutely get it. But let's look at it not from our perspective, but from the court's perspective. And from the court's perspective and court-appointed counsel, becoming the conservator in some ways makes the person more vulnerable if there aren't sufficient checks and balances, because we have, through a court order, given someone access to at least some of their funds. And in doing that, they could just run off. And so even though I know my clients aren't, I know they're not going to steal, they're all doing this because they care about this person and don't want bad things to happen to them. But the court can't know that, doesn't have a personal relationship. The system doesn't have a personal relationship. The system has an obligation to protect this person. So the best way to do that is to have the person bond for any money that they're going to have, cash that they're going to have, or property that they're going to have access to that they could steal. It's effectively insurance. It's a fiduciary bond that if that happens, the protected person has insurance and can recoup that money. And then the bond company can go after the bad conservator. So really it's a way of creating a layer of protection for that vulnerable person. So let's talk about how we calculate bond, because it's not for the entire estate necessarily. It'll depend on the estate. I like to sometimes put the statutes up because I want you to empathize with how I feel. I went to law school and I read this and I go, I read it again. I'm like, what? Still, what does that mean? So I'm going to try to, don't worry about the statute. Just pretend I never showed it to you here. Let's not look at it. So a bond, the way to calculate the bond really simply is what the person is going to have, what the conservator cash they're going to have access to. So typically the yearly income that is getting automatically deposited into accounts. So that annual income is going to be money that's available. And then also any assets that need to be available to meet the person's care needs. So any shortfall, anything that's not covered by income that may be in an account that they need to have, the conservator needs to have access to. That plus a little bit is what you would bond for. So if the income was $100,000 a year and the shortfall, it's very simple, really simplifying, and the shortfall was $50,000 a year, I would probably want to bond for 150 at a minimum, maybe 175. Bonds do cost money. Usually you pay for 3 years. If you don't use the full 3 years, it gets prorated back. You pay up front, and then you have to renew the bond over time. So again, though, those fees are paid by the protected person's estate. Okay, we'll pass right by that statute and move on to our next slide, which is the court hearing. And then I'm going to talk about how it's all going to work together in the end. So the court hearing, there is going to need to be testimony. How much testimony is going to vary with your commissioner. And when I say commissioner, I mean that's a judicial officer. In Maricopa County, we have judges and we have commissioners. They all serve as judges. The commissioners typically serve as judge pro tem, so they can preside over any of the matters. We are all one Maricopa County Superior Court, so they can preside over any matter in Maricopa County Superior Court. That is true in other counties. If they have commissioners, they should be able to preside over anything. It will vary by county. So in Maricopa County, we're so big, we have an actual probate department. All the probate cases go to commissioners in that department. In other counties, that's not necessary, and you'll have judges who are hearing all different kinds of matters all day long. So testimony will need to be taken, and it will be up to your judge or your commissioner to decide if it was a verified petition, which means you basically swore under oath that everything you said in that petition was true and accurate. Sometimes they just want to know what's changed since you filed the petition. Is anything different? Update they should know about something that's changed. That may be the only testimony. Some want to really hear from the conservator and ask questions about their understanding of their duties and their responsibilities. You know, when is your address due? Did you do your trainings? Verify the relationship on the record. So it's going to depend on your judge or commissioner. If you have an attorney, they probably know what that person's style is unless they're really new, and so they can give you a heads up. Regardless, the testimony, if the person at that initial hearing, if the person is not objecting, then the court investigator's report will get admitted, the physician's report will get admitted, and you can move forward with the testimony and the appointment on that day because no one is objecting. In that case, the testimony is pretty brief, as I was describing, which is going to be what's new, or preparing to prepare. I would review, so I tell my clients, I'd review the petition that was filed and the order too that the person signed. So all their duties and responsibilities, and then the information that they provided to the court. If there is a physician's report, I would say review that too. Most often, my clients are very familiar with the impairment the person is suffering and what's been happening with their finances, but that's what you'll need to know. So that's if it's uncontested, assuming that we're going to get appointed that day. I'm going to take a little tangent here. If the person who is proposed to be protected, so let's just say in my example, it's mom or dad, and I'm representing one of their adult children, and they are saying to their kids, I'm fine. I've been managing my affairs since before you were a thought. I don't see an issue here. And they tell their lawyer, I don't want my kids to be in charge. I don't want to have a conservator. I don't think there is a problem. Then that would get set for a trial. That's a completely different presentation on how that's going to work. But I want you to understand where these two things, what might happen at this hearing. So either the person's not objecting, everything is in order, and we can move forward with the appointment at that initial hearing, or it's going to get set out for a trial, and there's going to be other deadlines and things that will need to happen, and that testimony is going to look very different. It's going to be way more in depth. That's really getting up. You're looking at a picture of really being on the witness stand. That's going to look very different and would be a different presentation. We're going to assume for today that the person is not objecting and we're moving forward with that appointment. So the proposed protected person also has to give their position. So I was talking about the testimony of the petitioner. Most often what happens is we go into court, and because we need to know which direction it's going, the judge will usually start with court-appointed counsel and ask for the person's position on the conservatorship. Do they object or not object? Typically, the person is present at the court hearing, and sometimes they want to say something. That initial hearing is not the time to be telling your story. It's procedural in nature. It's just, are we objecting and moving forward with that appointment, or are we setting it out for trial? So be forewarned, this is not the time that we're telling the whole story of how we got here. So they will usually start with court-appointed counsel and ask for the person's position. For our purposes today, the person doesn't object. And so that's usually what they'll say is they don't object. And then the judge will ask, is there any objection to the admission of the court investigator's report or the physician's report, if there is one, or whatever information was submitted regarding the impairment, or does the person who's there with their lawyer agree there is some impairment? So that could go a few different ways. The court will verify all those things and then typically turn to the petitioner and petitioner's counsel and say, okay, here's what kind of testimony I want to hear. And then we'll get some direction that way. Now, if all the paperwork is in order, going all the way back to all of our steps, all those documents have been filed, proper notice is given, and that is one of the things the court will have to find at this hearing, is that proper notice was given. So the judge is going to walk through the affidavit of personal service. They're going to ask court-appointed counsel, was your client served? They're going to look at everybody else, look at your proof, and make sure that everyone was served. All of that stuff is done. They're going to take some brief testimony, and usually these last 10 to 15 minutes. Right now, because of COVID-19, they are all virtual. As we sit here right now, they're using GoToMeeting. They are moving to, at least in Maricopa County, a Microsoft Teams platform where they'll be able to do video conference hearings going forward into the future on a much more seamless platform. And I should back up. I should say in Maricopa County, they're all virtual. Other counties were handling it differently. We've done a few hearings in Pinal and Gila County, and we're able to appear virtually. So it's all going to depend. Normally, we would go down to the court. I don't know if that normal is going to shift, but basically the hearing looks exactly the same, whether you're in person or whether you are virtual. The question that's been coming up a lot is, if we're not all in person, then how does the protected person, how are they getting on? And what we've been experiencing is the facilities where they're living or the person they're living with has been really, really helpful in getting, because you can do it on a FaceTime, really any tablet, phone, anything that's got a microphone and a camera, you can do the hearing virtually from that. And so that's how we've been able to have people there as best they can. Some people who are the protected person aren't able to really track the hearing, and so if they get up and move around, that's okay. When hearings are in person, I am asked a lot if the person has to attend. If they've been personally served and their lawyer agrees that their attendance would not be helpful or not in their best interest, then we can have, they can agree to waive their presence. We also can get physician information that says this person should not come. I have some people who it would be it would be dangerous if they're let's say they're in the intensive care unit, it would be dangerous to transport them to the hearing. And so we just let the court know that is not an option. They've been served, and then they appear through their representative. So we've made it all the way through the hearing. Whew, that's the hard part. It's a lot of steps, a lot to go through. So here we are, we're all the way at the end, but it's just the end of the beginning, right? Because there is still a lot to be done. I mean, this is just getting you appointed. So after the hearing though, just because you went to it doesn't mean you're appointed. You're still not quite there yet. I'm going to talk about it like we're in person, and then I'm going to go through what the procedure is while we're not in person. So when we're in person, we would all go into the courthouse. The clerk would give me a copy of the order that is to be certified, and it's got a special stamp on it. It says copy for certification. I would take my client's letters, their original bond, their acceptance of appointment, and we would take that whole packet that I've been talking about down. We'd wait in line, and we would go and we would see someone at the clerk's office, and they would issue our certified orders and letters. So two very important practical tips. One, if your order and letter is certified, there is a staple at the, I wish I had a document, imagine a document, there's a staple in that top corner. These cost $28, and at least in Maricopa County, and that staple is what costs $28, because if you unstaple it, you decertify the document because the certification is on the back. It's a stamp, an embossed stamp on the back of the last page of the order. So if you take it apart, you sort of decertify the document because you could have put pages in between. And so when you go to Social Security or something like that, they'll look to see if the staple has been removed. And if it has, it's not a certified document. Social Security, vital records, the government agencies typically like to see a certified document, as well as financial institutions. So that's why it's important not to spend all the money to get your certified orders and letters and then just decertify them. So don't take the staple out. So 3 practical tips. Here's another one. So staple. Your letters are not valid, or your orders are not valid until you have letters issued. The conservator has to subject themselves to the jurisdiction of the court. And so they have to give their acceptance and their letters, and it's the issuance of that makes that appointment effective. And the third thing is count how many financial institutions you have, because you may need original certified orders and letters for multiple institutions, and particularly with COVID-19, we may be doing a lot of mailing and not able to take that certified order or letter in to various institutions. So right now, with everything being virtual, we're still getting our orders and letters issued, at least in Maricopa County and the 2 hearings we did in Gila and Pinal, very, very quickly. So we would appear, and then the court, the judge or the commissioner, the court clerk, they would fill everything out. So you send everything down 7 days ahead of time. It's back up to that. So they have all of your documents, except you have the letters and you have the bond and you have the acceptance, waiting for that order to come back. So what they would do, the judge would sign the order, make any adjustments we've made, whatever we're going to do. I would say we need this many certified copies, and I had to send down enough copies for as many as I wanted certified. So then I would say to the judge, I need 4, because I've got, I don't know, Fidelity, Chase, Wells Fargo. I know I've got this many that I'm going to need my orders for. And so the judge would say, okay, those will be in my outbox tomorrow, and they would give me a time. And then either the petitioner, or in my case, in my firm, I send down a runner, and they go and they pick those up for me. And then they also pick up the letters, the acceptance and the bond, and they'll pick up the order, and then they go and take and have everything issued by the clerk, because they are still allowing the runners to come in. They've got procedures in place to keep social distance and masks and everything. So none of this, fortunately, the court is still functioning and we can still get all of that done. And then it's going to be part 2, which I am going to do later in August, where we're going to talk about what happens next, because there's so much more. There's inventories and budgets and accountings and credit reports, and just getting appointed is just the beginning of that journey. So here are the upcoming webinars that we have in our series. I hope you'll join my partner next time, Emily Kyle, to talk about wills and trusts. She's just so darn smart about all of that. Every time I listen to her, I learn something new. So I hope you will join her. I'm sure it's going to be fantastic. Also, I'm going to be back here on August 5th. I'm having a conversation with the executive director of Raising Special Kids. I'm actually on the board. I'm the board chair of Raising Special Kids. So I worked really closely with him for the last couple of years as the board chair, and he's a really interesting guy. You'll learn everything about Raising Special Kids and what an amazing resource it is. Everybody should know about this organization. Helps all families, all kids with disabilities, any type of special need, any call, and it's free. So what more could I say? Great resource, and it's free. And then part 2 of this, we'll be back on the 19th to talk about that. If you want the full calendar, we are working on getting that up on our website. And I am so happy that you all joined me. And I am prepared to take questions. questions.
Okay. Hi, Jen.
Hi.
So I think you actually might have covered every detail, because I do not have any questions on my end. We can leave this up for a couple more minutes. In the chat bar, you guys can open up the window and type any questions you have to us, if you have any right now.
Wow, Sarah, if one of two things happened. Either I said so much stuff that everyone's just shaking their head and they're like, oh no, it's too much. Or I did a great job and I was super thorough. And so
I think that might be it.
I don't know. I'm nervous, you guys.
Well, I think you did awesome. I'm not seeing anything on my end.
Great. Well, I really hope that everyone will come back. We have typically done a lot of free public speaking out in the public, and we would talk to all kinds of nonprofit groups. Emily and I would, trying to get this information out to people. It's really fun for us because, you know, it's just a great way to share what we learned in law school, what we do every day, and I really enjoy it. And with the pandemic, we can't do that, so we're trying to find some other way to keep that dialogue with the community going. And so I'm really happy that everybody was here. Thanks for coming, and I hope you'll come back.
Great job, Jen. Thanks so much. If anyone has questions, you can definitely shoot us emails, info@kylecooplaw.com, or you can send an email to myself, Sarah, S-A-R-A, @kylecooplaw.com.
All right, thanks so much. Bye. Take care. Be well, be safe.